Mr. Beer, curious is a word which has been much used in this inquiry, and people may have noticed how curious I was to see people sitting in different places.
Yes.
Miss Greeny, I think we're ready for you, though the door hasn't shut at the back yet, so I'll let you know when they've shut the door so that you have the floor to yourself. Fine.
Sir, the inquiry has received detailed written closing submissions from Post Office in phases 2 to 7. I do not intend to rehearse the content of those submissions orally. I propose to address some headline points which will not take up the full hour that has been allocated. Post Office recognises that its actions, as explored by this inquiry, have caused harm and suffering to postmasters, their families, and to many others. I would like to start by reiterating Post Office's apology for the damage that it has caused to every person who has been affected by the Horizon IT scandal. This inquiry has been a humbling experience, not only for those that gave evidence, but for those that currently work at Post Office or used to, and who are all equally appalled by Post Office's failures. No one who has read and listened to the evidence during this inquiry could come to any conclusion other than that the Horizon IT scandal is the most widespread miscarriage of justice in British legal history, and that its roots lay in fundamental structural and governance failings. As the inquiry will have seen from the evidence read and heard in Phase 7, Post Office today is a different organisation from the one that was in place during the failures of the past. But it still has a long way to go to reset its relationship with postmasters and the public. Post Office is not perfect and does not pretend to be, but it is firmly committed to continuing to learn lessons from this inquiry. It will be considering the proposals for improvements made by other core participants in their closing statements as part of its ongoing work. The new leadership at Post Office brings a fresh perspective, and they are committed to making the changes that are necessary to restore confidence in the business and to ensure that nothing like this will or could ever happen again. Post Office acknowledges that it will rightly be judged in the months and years to come by what it does, not by what it says it is going to do. Post Office has sought to assist the inquiry in fulfilling its terms of reference to understand and acknowledge what went wrong in relation to Horizon in order to identify what key lessons must be learned for the future. The scale and scope of the evidence heard by the inquiry over the last 2+ years is vast. That includes evidence from postmasters, as well from a very significant number of witnesses who were or are employees of Post Office. The inquiry heard from those in senior positions in Post Office, as well as those in less senior roles, dealing with day-to-day issues with postmasters. Post Office acknowledges that the inquiry will rightly be critical of a number of individuals, not only from Post Office. It invites the inquiry to bear in mind the serious governance and structural failures that permitted their actions to be unchecked, resulting in failings to the detriment of postmasters. Post Office raises this not to excuse, but to explain the context in which those failures occurred. The combined testimony of the witnesses heard and the hundreds of thousands of documents disclosed by Post Office to the inquiry has Post Office hopes given the inquiry detailed insight into the workings of every relevant aspect of Post Office's business over the last 30 years. In the early phases, the inquiry heard from witnesses who joined the post office in the 60s and 70s, several coming to occupy the most senior positions some 20 or 30 years later. A picture emerged of a company in the late 20th century and the early part of this century, which certainly at a senior level had little experience and understanding of the IT revolution which had already taken place in many other companies and which it was inevitable that Post Office had to join. It is a source of deep regret to Post Office that the reliance on Fujitsu and of belief in the reliability of Horizon, which emerged in those early days, was allowed to take root within Post Office in the decades that followed. Post Office has referred in its written closings in earlier phases to a mindset that took hold in Post Office, to the effect that Horizon had no bugs, errors or defects. Such problems as did arise in Horizon were due to user error or dishonesty. A strong resistance to countenancing the existence of any flaws in Horizon. A mindset that saw it as an advantage not to keep postmasters informed about systems issues that were identified. A mindset that positively discouraged more widespread dissemination of information. A mindset that focused on protecting the Post Office brand and the commercial interests of the company. This mindset was compounded by an organisational hierarchy which meant that junior employees did not feel able to escalate issues upwards. This in turn resulted in insufficient overview being taken at senior level. Important senior roles were occupied by individuals who regrettably lacked sufficient understanding of the obligations and responsibilities attaching to those roles. They either did not have sufficient personal experience of Horizon technology or were not sufficiently senior within the overall organisation to carry out those roles effectively. Similar themes again emerged during the evidence heard during phases 5 and 6. Post Office has accepted in its written submissions for those phases that there was a series of governance failings in the organisation. Key information about Horizon and prosecutions based on Horizon was not shared effectively, either horizontally or vertically within the Post Office, and there was no clear structure to ensure that relevant knowledge was consistently and appropriately communicated throughout the organisation. As Post Office has acknowledged in its written closing statement for phases 5 and 6, the apparent lack of knowledge or understanding on the part of senior executives and board members that Post Office conducted its own prosecutions against postmasters was particularly striking. When Post Office separated from Royal Mail Group in 2012, there was a failure to ensure that incoming board members and senior executives were briefed either on the fact that Post Office was a prosecutor or on the central importance of Horizon data to those prosecutions. There was a lack of clear lines of accountability for reporting on prosecutions to the board, which created the structural conditions for inadequate board oversight of prosecutions. This in turn severely reduced the board's effectiveness in holding the executive to account. Similarly, there was a failure to share the first clerk advice or its substance with the Post Office board. This appears to have arisen from a collective failure on the part of the then Post Office legal team to appreciate its full significance and inadequate processes being in place for sharing the substance of key legal advice with the board, rather than a deliberate attempt to prevent the advice being considered by the board. Consistent with the prevailing mindset that has been revealed in the evidence in phases 3 and 4, Post Office's response to the Second Sight interim report showed multiple failings on the part of the executive. They adopted a defensive attitude from the start to Second Sight's negative findings, and consistent with an assumption of postmaster fault, refused to entertain the possibility that Horizon or Post Office's treatment of postmasters including inadequate training and support, were to blame. The evidence also shows that the board failed properly to scrutinise either the Second Sight interim report or Susan Crichton's update paper for the July 2013 board meeting. Given the concerns raised about the existence of bugs, about Post Office's investigation function, and about the treatment of postmasters, the board's failure to challenge the executive was a significant one, particularly given the concerns raised by the board about claims for wrongful prosecution leading to a notification to insurers. As I said at the outset, I do not intend to rehearse or seek to summarise the points that have been made in the written closing statements of Post Office for all phases. Post Office focuses the remainder of this oral statement on aspects of the work that it has done since the judgments of Mr. Justice Fraser in the Common Issues and Horizon Issues trials to bring about organisational and cultural change to address the failures identified and to ensure that the wrongs of the past will not be repeated. Since 2019, Post Office has taken steps to shift its focus to postmasters. Post Office accepts that the pace of change in the organisation has been too slow. Post Office acknowledges that it has a lot of work to do in order to address its shortcomings and rebuild the trust of postmasters that has been so severely damaged by its failures, and that it is actions rather than words that count. Post Office has implemented a number of changes since 2019 to start reorientating the business towards the interests of postmasters, which I will deal with under the following headings. 1, listening to the views of postmasters. 2, changes to its discrepancy processes and the support it provides to postmasters. 3, horizon improvements. 4, cultural changes. 5, governance changes. And 6, Post Office's plans for the future. First, Post Office acknowledges that it failed to listen to and act on the concerns of postmasters about the Horizon system. Since the events which are the subject of this inquiry, it has taken steps to bring the views of postmasters into the centre of the business. Since June 2021, Postmaster NEDs have sat on the Post Office board, which has enabled the views of postmasters to be heard on matters of strategic and key operational importance. Following the recent appointment of 2 new Postmaster NEDs, continuity will be ensured by 1 current Postmaster NED remaining in post until June 2025. In addition to the Postmaster NEDs, in 2021, Post Office appointed a Postmaster Experience Director who spends 2 days a week in Post Office head office, liaising with the executive teams to inform them about the operational experiences and concerns of postmasters. Furthermore, Post Office has plans to expand the mechanisms for enabling the views of postmasters to be heard and taken into account in the business. First, the Post Office panel will work with Post Office to ensure that the postmaster voice is heard at an operational level by considering and challenging key policies and processes and communicating the work of the panel to postmasters in order to build confidence. Secondly, the Consultative Council will enable Post Office to consult with postmasters on the future plans for Post Office that arise from the implementation of the strategic review, so as to make sure that the views of postmasters are taken into account and considered in the changes that are proposed. Second, Post Office has changed fundamentally the way it investigates discrepancies shown on the Horizon system and the support it provides to postmasters. The inquiry has read and heard detailed evidence from Tracy Marshall, Retail Engagement Director, and Melanie Park, Central Operations Director. The burden of proof is now on Post Office to establish that a discrepancy is a genuine loss to Post Office and the fault of the postmaster or their assistant. This is a crucial step in addressing the imbalance of power that previously existed in Post Office's policies, procedures and practices. In cases where the postmaster does not agree with the post office's position, there is a dispute button on Horizon that a postmaster can press to raise a discrepancy or dispute a transaction correction that has been issued. There is a 3-tier dispute resolution procedure and the option of a referral to a dispute resolution review committee. Post Office provides improved support to postmasters through Branch Hub, a digital platform which provides information, including manuals and training materials, to help and support postmasters and their staff on a day-to-day basis, and which postmasters can also use to report IT issues. Any defects or issues relating to Horizon are set out in knowledge articles, which are published on Branch Hub within 48 hours of being identified. These articles serve an important role in ensuring postmasters are kept up to date and have the information they need should a discrepancy arise. Post Office intends that these processes will be kept under review by the Postmaster Panel with the aim of ongoing improvement. The inquiry will bear in mind that Post Office no longer exercises a prosecutorial function. It does not now and has no intention in the future of conducting its own criminal investigations or prosecutions. Post Office will support law enforcement agencies in their investigations, as it plainly should. Third, the inquiry has heard detailed evidence from Simon Oldnall, Branch Technology Director at Post Office, and Tracy Marshall, in written and oral evidence, that Post Office has worked hard through the Horizon Improvements Programme to remediate bugs, errors and defects, including those identified by Mr Justice Fraser. It has put in place a programme to identify and fix any new bugs, errors and defects in Horizon, and carried out significant work to establish an ongoing programme of improvements to a wide range of procedures across many parts of Post Office's operations, including training and business support. The inquiry has also received detailed written evidence from Mr Oldnall about the way in which Post Office now better monitors Fujitsu's compliance with Fujitsu's own contractual obligations to provide a secure and reliable Horizon system. The inquiry is aware that Post Office continues to be in ongoing discussions with Fujitsu about an extension to the Horizon contract. Fourth, the inquiry has heard that from the end of 2019, Post Office has introduced initiatives intended to bring about cultural changes across the organisation. Post Office has recognised the need for fundamental cultural change. As Nick Reed said in his first statement to this inquiry, Post Office recognises the presence of oppressive behaviour and intimidating actions in the past, which led to a lack of respect and trust between Post Office and its postmasters. It acknowledges that there has been a lack of effective leadership, a lack of effective training and support, and a lack of responsibility within the organisation. It accepts that it has work to do to restore trust with postmasters and with the public as a whole. Cultural changes in the Post Office are integral to the rebuilding of that trust. To remind the inquiry, those initiatives to reset the Post Office's culture include the following: the introduction of new training modules, including substantial induction training, which educates new employees about the Horizon IT scandal, and mandatory Horizon scandal training and GLO awareness. In June and July 2024, the Post Office launched a behaviours framework that applies to all those working in Post Office, which is intended to act as a guide and to instil behaviours that are seen as key to preventing a repeat of the wrongs of the past. New complaints channels have been implemented via the Postmaster Survey, College Engagement Survey and Strategic Partner Survey. These changes are not just aspirational. The new behaviours framework is embedded into the recruitment process and used to measure the performance of everyone at Post Office. The board takes ultimate responsibility for ensuring that cultural change takes place, but every person working at Post Office has their part to play. Cultural change, of course, takes time. However, recognising that change has not happened quickly enough, Post Office has put in place plans, including a strategic people plan, which are intended to embed cultural change from the foundation of the organisation upwards, focusing on building better relationships with postmasters with a real emphasis on restoring trust. A key objective of Post Office's recent strategic review, which I shall come on to talk about shortly, is the commencement of a new relationship between Post Office and postmasters, in which there will be a significant increase in postmaster remuneration, improved support, and the strengthening of the postmaster voice. Post Office sees this proposal as underpinning the drive towards a reset of the culture in its business. Fifth, Post Office has acknowledged in the course of written closing statements made in respect of earlier phases, including 5 and 6, that there were serious governance failings in the organisation, which played a substantial part in the injustices that occurred. Post Office commissioned Grant Thornton to review its corporate and operational governance in 2023. Post Office accepted Grant Thornton's conclusions that it requires a unifying strategy, greater role clarity, streamlined decision-making processes, significant improvements in succession planning, and a cultural shift towards accountability and long-term planning. To address the need for a unifying purpose and group strategy, which Grant Thornton considers lies at the heart of governance dysfunction at Post Office, Post Office has commissioned a strategic review. Post Office has taken action to address governance issues identified by Grant Thornton where it has been able to, pending the outcome of the strategic review. It has taken steps to improve the composition and competency of the board. The interim general counsel is now a standing attendee at board meetings. Action has also been taken to improve the quality of information on which the board reaches decisions, and measures have been introduced to avoid the board being overburdened with issues that ought to be dealt with at executive level. The group executive, now called the Senior Executive Group, has been restructured so as to focus discussions better and improve the speed of decision making. A wholesale review of executive committees is underway. Post Office notes the proposals put forward by others for alternative governance structures, including an oversight committee, as proposed by the NFSP. It also notes the view of the governance experts that responsibility and accountability should rest with the board. Post Office considers that, at least to some extent, the NFSP's proposals for an oversight committee will be addressed by the proposal for a Postmaster Consultative Council, which will work together with Post Office on the implementation of proposals arising from the strategic review. 6, through the strategic review, the new team at Post Office has put forward a proposal to government for the future of the Post Office, which will enable it better to serve the interests of postmasters and thereby the public that they serve. Post Office has been pressing for a review of government's policy as sole shareholder in respect of Post Office for some years. Post Office has been loss-making since its separation from RMG in 2012, and in the face of significant commercial and structural challenges, those losses are expected to worsen in the future. The government has nonetheless long held the view that Post Office should be financially self-sustaining and not rely on government subsidy. Post Office is looking forward to receiving greater clarity from ministers as to how that could or should be achieved and the policy objectives that would underpin it. Post Office considers that the changes that it seeks to make as part of implementing its strategic review will be far-reaching and to the benefit of postmasters first and foremost, but also to the long-term future of Post Office as a whole and the communities that are served by Post Office. The review, carried out between June and September 2024, drew on members of Post Office staff, board members, postmasters and other stakeholders and experts. Nigel Railton, interim chair of Post Office, stated in his speech on the 13th of November 2024, fundamental to the implementation of the strategic review is Post Office's plan to deliver a new deal for postmasters. This will significantly increase the total annual income of postmasters through a vastly improved share of revenues and strengthen their role in the direction of the organisation. The implementation of the strategic review will be informed by strong postmaster engagement through the establishment of a new consultative council and a postmaster panel. The strategic review is also aimed at refocusing the Post Office's operations so that there is a streamlined central organisation which serves the interests of postmasters so that they may serve their communities via sustainable businesses. Nigel Railton, the interim chair, explained in his evidence to the inquiry that as a result of the strategic review and subject to DBT approval, Post Office proposes to reset the MBIT programme to improve confidence in its delivery and to ensure that it provides what postmasters need. Post Office intends to work closely with postmasters to define the new programme. Post Office acknowledges that work needs to be done to ensure that its proposal remains aligned with the work being carried out by DBT, with Grant Thornton, Boston Consulting Group and the Government Internal Audit Agency. Post Office welcomes continued involvement in DBT's reviews. The inquiry has also heard that the government is planning a green paper on the future of Post Office, which will be published in 2025. Post Office is now at a critical juncture. The organisation has a new and experienced interim chair and interim acting CEO, a relatively new board, and a SEG team who are skilled in delivering transformation change of this nature and are committed to implementing the plans so critical to the Post Office's future as set out in the strategic review. Post Office is already doing what it can to push forward its plan for transformation with structural and technological changes whilst waiting for funding decisions. Ultimately, it is in the government's hands as to whether it agrees with the proposed strategy and whether that strategy will be funded. Post Office considers that its plan to transform the Post Office offers the best opportunity for the organisation to flourish and benefit those whom it serves, namely postmasters and the public. Post Office recognises that until all postmasters receive full and fair redress, there is no prospect of them achieving closure in respect of these terrible events. Post Office remains fully committed to playing its part in ensuring that postmasters receive full and fair redress as quickly as possible. It has been the long-held view of Post Office that the compensation scheme should be run independently of Post Office because the perpetrator of injustice should not administer the assessment of redress. It is also Post Office's view that legal advice should be offered when the £75,000 fixed sum is offered to postmasters. Simon Recaldin has informed DBT of his view that there should be consideration of extending the schemes to family members, and Post Office welcomes DBT's consideration of this. Post Office notes that DBT has provided an update on financial redress in its written submissions. Post Office regularly updates the HSS and the OCS web pages with the current figures. Post Office would be happy to provide further written updates to the inquiry as to the progress of the redress schemes, if that would assist the inquiry. Furthermore, if the inquiry would be assisted by receiving written updates or further information from Post Office on other matters, then Post Office will of course provide such information as may be requested. Post Office would like to extend its thanks to postmasters who have given evidence or engaged with this inquiry as core participants, or by responding to the YouGov survey. Post Office wishes to thank the Chair, Ms Eliasson Norris, Mr Page, and the Inquiry Counsel and Solicitor teams for their thorough investigation and examination of the evidence. Post Office will reflect carefully on the findings in the forthcoming inquiry report and will take the inquiry's recommendations extremely seriously. Post Office must end this closing statement as it began, with an apology. Post Office repeats its sincerest apology to all who have been affected by its actions, and reiterates its determination to continue with the process of learning the lessons from this inquiry. Post Office remains firmly committed to ensuring that nothing like this could ever happen again, but acknowledges that it will rightly be judged in the months and years to come by what it does, not by what it says it is going to do.
Thank you, Ms. Greene. Ms. Leek, it's a matter for you. If you're going to take, sorry, I'm addressing Ms. Leek now. If you're going to take a full hour or thereabouts, then I think we'll probably take a break now, rather than ask you to break somewhere in the middle. I guess you'd prefer that, yeah?
I would, sir.
Yeah, right. So we'll take a break now.
Thank you.
And what's the time now? So we'll break till 10:15, and then we'll hear from Ms. Leek. All right, I think we're about to start again. I'm glad there's some self-discipline going on by people in the audience telling other people to be quiet because they won't listen to me. Right, Ms. Leek? Over to you, Ms. Leek.
Thank you, sir. So in our written submissions, we have sought to analyse carefully and forensically the chronology of what Ms. Venables did and did not know about various key matters and what she did and did not do with that knowledge. That document has now been published by the inquiry. We submit that it is only by looking forensically at all of the documentation that a fair picture of Ms. Venables' actions can be seen. In the time we have allotted to us today, I shall highlight a number of points from our written submissions which go to information provided to Ms. Venables which was incomplete or incorrect, or which she was not given at all. In our written paper, we have made submissions of general application on several topics. I do not propose to repeat them here, save to make one point. When witnesses have given recent evidence of matters relevant to Ms. Venables, without there being support in contemporaneous documents, this evidence should be approached cautiously. It is inevitable, having regard to the very human desire for self-preservation, that witnesses will now seek to distance themselves from Ms. Venables. Just two examples, if I may. First, Jo Swinson said in her oral evidence that Ms. Venables knew about the Clark advice. When I asked her questions about this, Ms. Swinson conceded that this assertion was based on a single email, which she had not seen at the time. That email does not withstand the weight which Ms. Swinson now seeks to load upon it. She did not have any personal knowledge on the issue, but clearly, and in retrospect, wanted to assume the worst of Ms. Venables and sought to point the finger at her. In his oral evidence, Alan Cook, the managing director of Post Office between March 2006 and early 2010, stated that Ms. Venables probably authorised in 2006 substantial legal costs for Post Office's claim against Mr. Castleton. This could not be correct. In fact, Ms. Venables did not join Post Office until January 2007. So I now turn to the chronology of Ms. Venables' involvement, which cannot, for obvious reasons, be a complete chronology. Even in 140 pages of written submissions, we could not set out a complete chronology with reference to every relevant document. Ms. Venables was CEO of a newly separated, highly complex business with more than 11,000 branches. Her role as CEO, and before that as network director, stretched far more broadly than Horizon to financial management, stakeholder engagement, strategic planning and decision-making, regulatory matters, and the financial success of the company. Sir, I do not raise that to downplay in any way the importance of Horizon, simply to highlight the huge demand of competing priorities on the CEO of a business of this size and nature. So I now turn to bugs, errors, defects, and remote access before Ms. Venables became CEO. Paragraph 88 of Mr. Steen's submissions suggest, I quote, "It is simply not credible for Ms. Venables to have uncritically adopted the mantra that she put forward in a letter to Lord Arbuthnot on the 9th of January 2012. She said, 'There has been no evidence to support any of the allegations, and we have no reason to doubt the integrity of the system, which we remain confident is robust and fit for purpose.' He relies on this assertion to suggest that the organisation was corrupt from the top. Sir, it's easy to make assertions such as this with hindsight, knowing what we know now about what has been found regarding bugs, errors, and defects. But from a close analysis of the contemporaneous documentation, it can be seen exactly why it was reasonable for Ms. Venables to make this statement, and it was not out of a corrupt motive. So far as Ms. Venables was aware, she had a competent head of IT and a competent general counsel on whom she believed she was entitled to rely. Taking over the helm of Post Office at the time of separation from RMG, as we have heard, was a gargantuan task. It was simply not possible to delve personally into each matter raised, nor realistic that she would have the expertise in all disciplines to do so. Why should she not have been entitled to trust Miss Crichton, Mr. Young, and Miss Sewell to give her the unvarnished position? Ms. Venables had no background in IT and was never employed by Post Office in an IT role. Post Office had an IT department which included IT technical specialists and senior managers, for example, Mr. Young and later Miss Sewell, whose role was to keep the board and the executive team informed of important matters. Ms. Venables relied, and submits that she was entitled to rely, on Post Office's IT function to provide accurate information to her, to the board, and to the executive team in relation to matters of Horizon integrity. So until March 2012, when he left Post Office, Mike Young was the most senior manager with responsibility for IT in the business. He reported directly to the managing director, first Alan Cook, then to Dave Smith, and then to Ms. Venables. Mr. Young confirmed in his evidence that it was his responsibility to ensure that IT-related issues were resolved and to ensure that the board was notified of IT issues which required its input or oversight. Mr. Young said that he was only ever aware of 2 bugs, errors, or defects, otherwise known as BEDS, in Legacy Horizon, blue screen and ISDN errors. The only BEDS he was aware of in relation to HNGX were BEDS which affected the Oracle database during the test and the pilot rollout. He said he had no knowledge of any BEDS that would have caused transaction or reconciliation errors in branch accounts. And the only occasion mentioned in his witness statement, or indeed seen in the documentation, on which he escalated concerns about Horizon integrity to the board or the executive team, was when he alerted Mr. Cook and the executive team about the Computer Weekly article in May 2009. Mr. Young repeatedly made and supported comments to Ms. Venables and the board which asserted that Horizon was reliable. He approved the approach and wording of a draft letter sent in Ms. Venables' name to Mike Weir MP in November 2011, which described Horizon as rigorously tested and said that there was no evidence at all that Horizon has in some way been at fault. Mr. Young's evidence is that he first became aware about the integrity of Horizon becoming an issue when he was contacted by Computer Weekly shortly before the publication of its article in May 2009. He told Computer Weekly this: Horizon is an extremely robust system which operates over our entire post office network and successfully records millions of transactions every day. There is no evidence that points to any fault with the technology. We would always look into and investigate any issues raised by sub-postmasters. It was around the same time that Ms Venables first became aware of concerns by way of the Network Functional Report for April 2009. That report included this unambiguous statement: legal advice is that we have no reason to doubt the system's integrity, and this has been tested in the courts. Ms Venables was given assurances from experts that there was nothing wrong with the system. The clear message being given by both legal and IT was that there was nothing to worry about. So the receipts and payments mismatch bug in HNGX was discovered in September 2010. It was discovered to have affected up to 62 branches, with 2 branches being impacted twice. Fujitsu prepared a paper dated the 29th of September 2010 for a meeting with Pol to discuss the bug. They noted that the bug was impacting around 40 branches. Mr. Young accepted that he was informed of the bug in February 2011, several months after its discovery. Ms. Sewell was aware of the bug by the 4th of March 2011. Ms. Venables was not made aware of the bug until May 2013. The inquiry has heard no evidence to the contrary. Mr. Young and Ms. Sewell both accepted that they did not escalate their knowledge of the bug to Ms. Venables when they first became aware of it. The evidence is clear that Mr. Young did not escalate his knowledge of the bug before he left Pol in 2012, and that Ms. Sewell did not escalate her knowledge at any point prior to May 2013. So coming to remote access between 2007 and 2011, the evidence before the inquiry establishes that between 2008 and 2010, a number of Pol managers, including Andrew Wynne, Rod Ismay, and Angela van den Bogert, then a senior network manager, were made aware that Fujitsu had the power, or a potential power, to change branch accounts remotely without the authority or knowledge of the affected sub-postmasters. This information was not passed on to the board or to Ms. Venables. On the contrary, the message given internally to Pol's executive team was that it was not possible to make changes to branch accounts without the knowledge or consent of the relevant sub-postmaster. Ms. van den Bogert and Mr. Ismay knew, at the latest in early 2011, that Fujitsu could, in certain circumstances, alter branch data remotely without sub-postmasters' knowledge. They were 2 of a substantial number of Pol managers who had been made aware of this by the 5th of January 2011. There is no evidence that any of these managers escalated their knowledge to the board or the executive team. It is clear from the oral evidence of 2 of the most senior managers involved, Mr. Ismay and Ms. van den Bogert, that they did nothing to escalate their knowledge. Ms. Venables still does not understand why they would not have done so. The knowledge with which Mr. Ismay is fixed runs directly contrary to what he had written in the Ismay report as to there being no backdoors in Horizon. He did not return to his report and seek to correct anything. When asked why this was the case, he offered no explanation for his failure to do so, other than he could not recall receiving the message as to remote access being possible. Turning to the 2010-2011 Ernst & Young audit. The EY audit of the control environment at Fujitsu for the financial year ended 27th March 2011 included the reporting of weaknesses in the IT governance and control framework, particularly in relation to Fujitsu and Horizon, and made recommendations for improvements. EY's detailed observations included, on page 33 of the management letter, that, I quote, there are inappropriate system privileges assigned to the AppSup role. The risk associated with this weakness was, I quote, unrestricted access to privileged IT functions increases the risk of inappropriate/unauthorized access, which may lead to the processing of unauthorized or erroneous transactions. Ms Venables was briefed on this audit report by means of a document which appears to have been prepared by Fujitsu in April 2011, with input from Ms Sewell. Ms Venables has no reason to think she did not see this briefing. And so this very issue was considered at the Post Office Board meeting on the 29th of May 2011, at which the board discussed the steps being taken to implement EY's recommendations. What Ms Venables did not know, though, was the significance of the finding which EY had made. She did not know this because she was not told that the existence of the AppSup role created this risk to the integrity of the accounting data held in the system. Ms Venables gave oral evidence that it is unlikely that she would have understood at the time, without advice from an IT expert, that EY's comments about the AppSup role showed that Fujitsu could make changes to branch accounts without the authorization of sub-postmasters. So the inquiry can be confident that Ms Venables is right that she was not told that the AppSup role could potentially be used to make unauthorized changes to branch accounts. First, there is no evidence that she was told. And second, the reason why she was not told is obvious from Mr. Young's evidence. He knew that, as with most IT systems, it was possible to gain access to the system remotely, and that Fujitsu could make changes to branch accounts with sub-postmasters' consent. However, he, head of IT, had, in his words, no belief, understanding, or even inkling that Fujitsu made changes to branch accounts without the authorization of sub-postmasters. Ms Venables was not told that there was a risk that Fujitsu could use its AppSup privileges to tamper with branch data, because Mr Young did not himself appreciate that this was a real risk. In the meantime, in a report to the Royal Mail Group ARC in December 2011, Chris Day, the CFO, together with Leslie Sewell and Rod Ismay, stated, and I quote, "As a result of the process and controls in place, POL is fully confident in the Horizon computer system operating in its branches. This accounting system and the processes around it enable our branches to maintain accurate and reliable accounts." The text of this report, sir, was run past Mr. Young and Ms. Crichton for comment. The report also stated, with regard to prosecutions, that, I quote, "POL remains satisfied that this money was missing due to theft in the branch. Due to the controls set out above, POL does not believe the account balances against which the audits were conducted were corrupt." This is the very same message that Ms Venables was receiving from finance, from IT, and from legal. So moving on chronologically to the instigation of the second site review. We see other clear examples of Ms Venables receiving incomplete or incorrect information from trusted colleagues in the information and briefing documents she received from meetings with MPs on the 17th of May and the 18th of June 2012. Ms Venables' straightforward submission in this regard is that she was entitled to rely on an unequivocal statement to the board by the General Counsel for its factual accuracy. Ms Crichton had said at the board meeting in January 2012, "The business has also won every criminal prosecution in which it has used evidence based on the Horizon system's integrity." Ms Venables had no reason to question this. This information was then transposed directly into what Ms Venables said to James Arbuthnot on the 18th of June 2012. "Every case taken to prosecution has found in favour of the Post Office." Ms Venables now knows and accepts that that was false. She still does not understand why Ms Crichton failed to give her accurate information, but would not have considered that she needed to verify what she was being told by her General Counsel. As for the conduct of the second site review, between mid-2012 and July 2013, Second Site and POL investigated the cases referred to Second Site by MPs and the JFSA. Ms. Venables was not involved in the investigation. It required subject matter expertise. Post Office established a working group to consider the evidence presented by Second Sight and to formulate Pol's response. Its membership drew together knowledge and expertise in IT, accounting, security, and network operations. In addition, a group of managers, including Mr. Baker, an IT specialist, and Ms. van den Bogert, a senior network manager, were tasked with liaising directly with Second Sight. Ms. Venables did not attend meetings of the working group. She had no role in directing or deciding what information Post Office would provide to Second Sight, and she was not involved in or consulted about Post Office's substantive responses to the cases. These were operational matters which required the specialist know-how of the teams dealing with Second Sight. The evidence shows that Ms. Venables received oral and written updates, mainly from Ms. Lyons and Ms. Crichton, to report on the progress of the review and to prepare her for meetings with stakeholders. Sir, one matter on which Ms. Venables did need visibility was whether Second Sight or the Post Office teams engaged in the project had identified problems with the Horizon IT system. The information she received during the review was that neither Second Sight nor Post Office had identified any system-wide problems with the IT system, being briefed in those terms in an email from Ms. Crichton on the 19th of March 2013, and for the call with Lord Arbuthnot on the 23rd of May 2013. The key message in that briefing being, we are concerned that the investigation is overrunning, that the findings will not be definitive, and there will be no satisfactory outcome to the Horizon question. The message at 2.6 was, the investigation has been running for a year, and to date no evidence of systemic failures has been found. And at 5.3, Post Office is not saying Horizon is free from defects. Systems of this nature occasionally encounter problems. We are confident, though, that no sub-postmaster has been wrongly convicted or suspended due to Horizon defects. In addition, she was briefed for the board call on the 1st of July 2013 as follows. Notes for board update on Second Sight investigation. She was told, Second Sight due to present initial findings at a meeting with James Arbuthnot, MPs and JFSA next Monday. Report will focus on 4 best cases in detail, following an initial review of nearly 50 cases overall. Key point to emphasise is that we understand Second Sight have not identified any systemic issues with Horizon itself. However, the report still presents significant reputational risks for Post Office. SS nervous about perceptions of a whitewash, and so may draw attention to 2 points. The 2 points being, A, issues with Post Office's wider support, and B, the fact that we have disclosed 2 previous anomalies with the Horizon system, which they may suggest means we cannot be confident that there are not more widespread problems with the system. And so this is what Ms. Venables is told specifically about this point. This is a red herring, she is told. In both cases, the errors were picked up and have either been or are in the process of being addressed with the affected sub-postmasters. A comprehensive audit has been performed to check that there weren't further cases we weren't aware of, and new procedures are being put in place to ensure such anomalies are spotted at an early stage in the future. What was she to take from this? It was a red herring. The bugs had been dealt with. There's been an audit to check whether there were other cases Pol wasn't aware of. So she is also then told, we also have other concerns around Second Sight's handling of the investigation. They haven't yet reviewed all the evidence we have given them, and hence may not be in a position to set out definitive conclusions on all 4 cases. She's also told it appears that they are not focusing on empirical evidence in the way we would expect forensic accountants to. So on the back of that last briefing note, Ms Venables briefed the board on the 1st of July 2013. Ms Venables shared with the board no more and no less than she herself knew about the likely contents of the Second Sight interim report as of 1st of July 2013. It was correct, based on what Ms Venables had been told, that the investigation to date had found no systemic issues. Ms Venables, in briefing the board, noted, quote, Horizon, like any large computer system, would occasionally have anomalies, and two were known of over recent years. Ms Venables described these anomalies, which she now recognises should have been called bugs, at the same time as stating that there were no systemic issues. That understanding of the belief of her colleagues and the findings of Second Sight was based directly on information she had been given by the working group. 2 days later, a briefing note on the Second Sight interim report was sent to Ms Venables by Chief of Staff Martin Edwards, with input from Susan Crichton, Alwyn Lyons, and others. Ms Perkins was copied in. This was produced before Second Sight had begun to circulate drafts of the Second Sight interim report, and was therefore based on the work that Post Office had carried out during the review and what they had been told by Second Sight. This repeated that Post Office believed that Second Sight had not found evidence of systemic problems within the Horizon IT system. The interim report at paragraph 8.2a clearly stated, we have found no evidence of system-wide systemic problems with the Horizon software. Second Sight were not required to include this conclusion in their interim report. They chose to include it, and a person reading the interim report was entitled to assume that it represented Second Sight's full professional opinion on that issue. A reasonable reader of the interim report as a whole would not have understood that the conclusion in 8.2a was based solely on the 4 spot reviews, as opposed to the totality of the investigatory work carried out by Second Sight, which they described in section 2 of the interim report. Further, the written briefing prepared for Ms Venables stated that Post Office understood that Second Sight had not identified any systemic issues in the 4 spot reviews to be attached to the Second Sight interim report, nor in the other 6 spot reviews sent to Post Office, nor otherwise during its investigation. In short, Ms Venables was told both by Second Sight and Pol's internal team of specialists that no systemic issues had been found during the investigation. Ms Venables submits that she was entitled to rely on what she was told. So turning to Ms Venables' understanding of the bugs that she was made aware of in 2013, Ms Venables was not an IT specialist, and as I've said, she relied on Pol's IT specialists for information about the bugs and their implications for the reliability of the system. 2 IT specialists reported to Ms Venables at the relevant time, Ms Sewell and Mr Baker. Ms Venables said that she relied on and was reassured by what she was told about the bugs. She submits that she relied on the Post Office IT team through Mr Baker and Ms Sewell in 4 main respects. First, to obtain and inform her of facts in relation to the bugs. Second, to provide their opinion on the significance of the bugs to the reliability of the Horizon IT system. Third, to inform her of any other bugs or defects which they were aware had impacted sub-postmasters. And fourth, to inform her if, in their opinion, Post Office should carry out further investigations into whether there were or could be other problems. As to these 4 issues, Ms Venables was told that the bugs had been detected by Post Office Limited processes, that the underlying technical problems had been diagnosed and fixed, that Post Office had been transparent with the affected sub-postmasters, and that no sub-postmaster had been left out of pocket. Ms Venables was told that the bugs were normal occurrences in a system the size of Horizon and did not indicate other or wider problems. What was important was how Post Office had dealt with the bugs. The 3rd of July 2013 briefing note to Ms Venables on the interim report gave the impression that the 2 bugs in HNGX and the Falkirk bug were the only bugs which impacted sub-postmaster accounts of which Post Office was aware. It dealt with the 2 bugs in Horizon Online and introduced the Falkirk bug by stating, "We are also aware of a further anomaly in Horizon." Post Office IT did not recommend a further investigation of possible defects in the system. Similarly unambiguous information was given to Ms Venables by Ms Sewell in July 2013 in respect of Michael Rudkin's assertion that he had met an individual in the basement at Fujitsu who demonstrated an ability to pass transactions directly into the Horizon system, and in doing so alter in real time or overnight the record holdings of foreign currency in Post Office branch offices. Ms Sewell said this to Ms Venables in an email on the 7th of July, quote, "Rudkin, we and Fujitsu have provided evidence to Second Sight that there was only testing systems in the basement in 2008. The equipment, brackets, hardware, and the testing system were located in the basement. This has been a constant challenge with Second Sight, as they contest that Rudkin has signed an affidavit, and therefore there is a conflict of evidence. There appears to be a lack of willingness to accept the detail we have provided. We have also had the tester, who Rudkin believes took him to the basement, complete a witness statement. He has confirmed that there was only a testing system in the basement. This has been a constant challenge with Second Sight, and I'm not sure how this will get resolved." The message that was communicated to Ms Venables in the contemporaneous documents was that Mr Rudkin's allegations had been investigated and that Post Office was satisfied that they had no substance. Sir, turning to advice on prosecutions. Ms Venables stated in a letter to the Bayes Select Committee on the 24th of June 2020 that she had discussed prosecutions with Ms Crichton shortly after she became CEO. She was told that Pol approached prosecutions with the same rigour as the CPS, applying the Police and Criminal Evidence Act 1984 and the Code for Crown Prosecutors. The documentary evidence that Ms Venables has seen since she wrote to the committee in June 2020 supports her recollection that she was given assurances that Post Office conducted prosecutions responsibly through a structured and professional legal process. This is consistent with the speaking note prepared for Ms Venables to use in May 2012 when speaking to Lord Arbuthnot. That note describes the role of Post Office as prosecutors and explains how internal and external lawyers would apply the same checks and balances as would be applied by the CPS. On the 3rd of July 2013, Ms Crichton sent an email to Mr Edwards and Mr Flemington discussing what would go into a speaking note for Ms Venables and Ms Perkins to use at a meeting with Lord Arbuthnot. Ms Crichton wrote in the email, "Nothing has emerged from the interim findings given to us by Second Sight which would point to specific convictions being unsafe. Cases have been through the judicial process and the court considers all relevant evidence, not just that relating to the Horizon computer system." That was the 3rd of July 2013. So these words made their way verbatim into the speaking note. Again, this is characteristic of the clear messaging that Ms Venables had been receiving and continued to receive from her General Counsel, and upon which she was entitled to rely. Turning to the Clarke advice and the prosecution case review. Simon Clarke sent his expert evidence advice to Post Office on 17th of July 2013, the day after the 16th July board meeting. Its circulation appears to have been limited to Ms Crichton, Mr Williams, Mr Flemington, and Mr Parsons of Bond Dickinson. Ms Crichton confirmed that the document was not sent to the board. Ms Crichton did not set out in writing anywhere a complete or accurate summary of the substance of Mr. Clarke's advice. It was her job to do so. Nor did her successor, Mr. Ojard. Indeed, while Mr. Ojard received a copy of the advice in a briefing pack from Cartwright King, he claimed not to recall whether he had read it in detail. He suggested that his view at the time was that it was a historic detail that was being dealt with through the case review process. This might go some way to explaining the messaging received by Miss Venables. Parts of Mr. Clarke's advice were communicated to Miss Venables between July and October 2013, though in a way which was piecemeal, unstructured, and incomplete. First, Cartwright King's advice that Post Office was obliged to review past prosecutions was summarised in Miss Crichton's update paper for the board meeting of the 16th of July 2013. Second, this paper did not mention Mr. Jenkins, nor the fact that Cartwright King had advised Post Office that it was obliged to disclose the 2 bugs in HNGX and the Helen Rose report. Third, it also did not mention that Mr. Jenkins and Post Office had breached their duties as an expert witness and prosecutor, respectively. The reason for this admission is that, as he said in his evidence, Mr. Clarke did not reach a conclusion that Mr. Jenkins and Post Office had breached their duties until shortly before he completed the Clarke expert evidence advice. As I mentioned, that was not sent to Post Office until the 17th of July, after the July board meeting. Fourth, Ms. Venables says that she was never told about Mr. Jenkins and Post Office's breaches of duty. She was also never told about the disclosure issues relating to the Helen Rose report. Fifth, Post Office obtained 3 pieces of written advice from Brian Altman King's counsel between August and October 2013. An interim review of Cartwright King's process for reviewing criminal cases for disclosure on the 2nd of August 2013, a general review of the prosecution case review on the 15th of October 2013, and a forward-looking review of Post Office's role as prosecutor. Each of these documents discussed the issue with Mr. Jenkins. None of them was provided to the board. They were each summarised for the board by the General Counsel in a way which gave the impression that Mr. Altman had not identified any significant issues with Cartwright King's conduct of the disclosure review or Post Office's conduct of past prosecutions. For example, Ms. Crichton emailed Ms. Venables after a conference with Mr. Altman on the 9th of August 2013, stating, I quote, "Overall, his opinion in conference was that the work that had already been completed was fine and along the right lines, taking into account Post Office's prosecutorial duties to disclose evidence/information to the defence." Sixth, Ms. Venables has a recollection of receiving 2 pieces of information by word of mouth after July 2013. First, she says that she was told by Leslie Sewell that Post Office had stood down a Fujitsu expert witness because he had not revealed bugs during the prosecution of Ms. Misra. Second, she was told by Ms. Crichton that Poll was required to review the cases in which the expert had given evidence. 7. When Ms. Venables was informed, most likely in October 2013, that Post Office had used an unsafe witness from Fujitsu, she informed Ms. Perkins, copying in the CFO, Mr. Day, and directed Ms. Perkins to contact Mr. Edwards if she needed more information about this issue. We submit that the inference to be drawn is that the information in the email was given to Ms. Venables by a Post Office lawyer. So Ms. Venables was neither willfully blind, as suggested by core participants, nor did she purposefully close her eyes. She trusted her general counsel. She was advised by Ms. Crichton that the right legal response to the disclosure issues was to conduct a review of past cases to ensure that Post Office complied with its disclosure duties. She was told that this review was in the hands of experienced external criminal lawyers and that their approach was being checked by Brian Altman, King's Counsel, a senior and experienced criminal barrister. She was also advised that Mr. Altman agreed with the approach of the external lawyers and had not found any fault in their work. So Ms. Venables made no attempt to influence or direct that process, save that she asked why the review should not extend further back in time to look at more cases. It was entirely for the lawyers to determine the steps that Post Office needed to take to comply with its legal duties, including what materials should be disclosed and to whom. Ms. Venables was given the impression by successive GCs that the case review exercise was being carried out competently and professionally, and fundamentally that the exercise was what Post Office should be doing as a matter of law to address the disclosure issues. As a non-lawyer, Ms. Venables could not be expected to have understood the significance of an unsafe witness and was entitled to rely on her general counsel, Cartwright King, and Brian Altman, King's Counsel, to ensure that Post Office was responding in an appropriate manner. Ms. Venables was not responsible for Post Office's failure to give disclosure of the fact that Mr. Jenkins had withheld information about his knowledge of bugs in Horizon in his expert evidence. Mr. Altman, King's Counsel, stated in his evidence that it did not occur to him at the time that this fact should have been considered for disclosure and disclosed in appropriate cases, although he accepted with hindsight that it should have done. The evidence before the inquiry has shown that this was not the only misjudgment or mistake made by the lawyers. First, Mr. Altman, King's Counsel, did not consider the procedure by which Mr. Jenkins had been instructed as an expert witness, because no one at Post Office told him that Mr. Jenkins had not been properly instructed. He stated, however, that looking back, this was something that he should have queried. Mr. Altman agreed that if he had been informed that Mr. Jenkins may not have been properly instructed or properly informed about his duties as an expert witness, this may have led to inquiries into broader failings by Cartwright King as prosecuting lawyers, and whether Cartwright King had a conflict of interest in advising Post Office on past prosecutions in which they had acted as prosecuting lawyers. Second, Mr. Clark accepted in his oral evidence that there was a view that Cartwright King's review of past prosecutions, and I quote, probably wasn't as independent as it ought to have been, and that Cartwright King's review may have become less rigorous and less observant of potential trends or themes in the cases as the review progressed. When he was asked whether Cartwright King may have become case-hardened during the review, he said, "That's exactly what I'm referring to. That's the point I'm making, that because you become slightly cynical, jaded, as inevitably is going to be the case, then you do miss things. Yes, I accept that." And third, Mr. Clark accepted that he was wrong not to have recommended disclosure following his review of Ms. Misra's case. Ms. Venables was not to know any of this. As Mr. Maloney, King's Counsel, said yesterday, regulated legal professionals might be expected to provide requisite independence. Ms. Perkins made the point in her evidence that the summaries of the external legal advice presented to the board were inadequate. They failed to alert the board to, amongst other matters, 1, the conclusions of the Clark expert evidence advice, 2, the existence and significance of the Helen Rose report, 3, Mr. Altman's view in his October 2013 general advice that Mr. Jenkins was tainted and that his future role as a witness was untenable, 4, the statement in Mr. Altman's general advice that he was left unclear about whether Poll had challenged Mr. Jenkins about his non-disclosures, 5, Mr. Altman's criticisms of the disorder of Poll's prosecution policies and past prosecutions, and 6, the possibility that Cartwright King were conflicted due to their role in past prosecutions, including those in which Mr. Jenkins had given evidence. Ms. Venables and the board at this time assumed, and were entitled to assume, that the General Counsel were complying with their core responsibilities to alert the board to legal risks and to provide accurate and complete summaries of external legal advice. That was their role. Ms. Perkins shared that belief. That is the only way to understand her evidence that the omissions from the summaries were shocking and extraordinary. When, therefore, Mr. Ojard presented his papers to the Audit and Risk Committee at the meeting in November 2013, and subsequently in writing in February 2014, setting out the options for Post Office's future prosecutions policy, he was doing so with the ARC proceeding on materially incomplete information. And he knew, or ought to have known, that this was the case, since it was he and his predecessor who had failed to provide the ARC with that information. There was no suggestion, for example, in Mr. Ojard's paper that Post Office should discontinue prosecutions because of there being any reason to suspect that its past conduct of prosecutions had been inadequate or inappropriate. The starting point of Mr. Ojard's analysis was that Mr. Altman had not identified anything during his review of Poll's prosecutorial role to suggest that Poll's approach to prosecutions had been anything other than well-organised, structured, and efficient. That was not an accurate summary of what Mr. Altman had said, nor did it sit happily with Mr. Clark's expert evidence advice or the Helen Rose report. The Post Office Board was entitled to assume that he was competent and that he would provide accurate summaries of the advice being provided to Post Office. So throughout her role as CEO, Ms. Venables and the board made use of highly reputable external advisors, including Deloitte, Linklaters, Bond Dickinson, Cartwright King, and leading counsel. As a non-lawyer, Ms. Venables did not seek to reach her own conclusions on legal advice, but preferred, as she ought to do, to take advice from experts. That can be seen, for example, in Ms. Venables speaking directly with David Cavender, King's counsel, about the tone of Post Office's case ahead of the Common Issues trial, and subsequently ensuring that the board was briefed on the proceedings by the external legal team the week before proceedings commenced. Matters such as the tone of Poll's voice were matters on which Ms. Venables, as a non-lawyer, could properly involve herself in the detail of decisions being taken. In contrast, a CEO could and should not be expected to add value in relation to questions of law on which, quite properly, the General Counsel took the lead, with Ms. Venables and the board receiving appropriate briefings. As for the mediation scheme, this process for seeking resolution of cases was recommended by Ms. Crichton following discussions with Bond Dickinson. On the 19th of July 2013, Bond Dickinson prepared a mediation proposal paper which contained, under the heading Workflow, what is clearly an outline of what became the mediation scheme. The statement that there were no grounds for a blanket compensation scheme appears to have come from advice set out in the Bond Dickinson mediation proposal paper. That, at present, there is insufficient evidence to justify a blanket compensation scheme for sub-postmasters. Each case needs to be considered on its individual merits. As the mediation scheme continued, Ms. Venables received assurance that the investigation of the cases had not revealed any faults with Horizon through a paper prepared by Chris Ojard on the 17th of September 2014 to update the board on the progress of the mediation scheme, and in briefing notes prepared by Mr. Bork in October 2014 and November 2014. Ms. Venables was also led to understand that the cases in the mediation scheme had been reviewed by external criminal lawyers who had concluded that there was no evidence of unsafe convictions within the mediation scheme caseload. Again, Ms. Venables submits that she was entitled to rely on statements made by the General Counsel and Mr. Bork, a qualified solicitor, for their accuracy. She was also entitled to believe, and did believe, that these statements were an honest and professional view based on the evidence reviewed by Post Office. Ms. Venables was aware that Bond Dickinson had been engaged by Post Office as its primary legal advisor in relation to the review, and that Post Office's investigation work included reviewing transaction data sourced from Fujitsu. At the time, Ms. Venables had no basis to second-guess what she was told about Post Office's view of the outcome of the investigation. Even contemporaneously, there is evidence in the documents that the Post Office senior team and its lawyers recognised that on occasion, Ms. Venables had not been given correct or incomplete information. When Ms. Venables gave evidence to the Bayes Select Committee on the 3rd of February 2015, she was not aware that Second Sight had requested access to Post Office prosecution files. 2 days later, she wrote to Mr. Richardson of Bond Dickinson on the 5th of February 2015, stating, "It was tough, but I felt that other than the issue of withholding prosecution files, which caught us completely by surprise, we did as you said." Further, an email from Ms. Crowe to Mr. Cameron, Mr. Davis, Ms. MacLeod, and Mr. Ojard on the 27th of February, which was copied to Ms. Venables, states that, quotes, "A clear, major breakdown in communications between legal and the CEO surfaced at the Select Committee on access to legal files." So Ms. Venables played no material role in decisions regarding disclosure or statements of factual witnesses and experts in the GLO proceedings. She does not recall being asked to be involved in any decisions about disclosure, and no questions were put to her in oral evidence on this topic. Ms. MacLeod, as General Counsel, took the view, set out in her witness statement for this inquiry, that in respect of whether or not to call somebody like Mr. Jenkins as a witness, quotes, "My expectation was that this would have been decided by the legal team." The inquiry may in fact have been surprised if it had heard evidence that Ms. Venables had personally made decisions regarding disclosure and witness evidence. That is far from the role of the CEO. So the protection of Pol's reputation. Ms. Venables submits that the protection of a company's reputation is a legitimate objective of a CEO. It is clear from the documents that Ms. Venables saw no conflict between the protection of Post Office's reputation and positive engagement with the Second Sight interim report. As she informed the board in an email on the 4th of July 2013, to summarise very briefly, we have taken the view that the best way to minimise the reputational risks associated with the review and to do the right thing for the business and the people is to welcome the broad thrust of the report and commit to acting on its key findings in relation to the need for improvements in our support and training processes. This is entirely consistent, she said, with the broader imperative for cultural change across the organisation, which the board has discussed in recent months. Ms. Venables saw the implementation of the interim report's recommendations on support and training as the primary means of preserving Post Office's reputation. In circumstances where Ms. Venables was being told that the IT Horizon system was reliable, but that there were areas for improvement in training, support, and culture, it is understandable why she took the approach that she did, to emphasise Post Office's confidence in the IT system, while accepting that it should proactively identify and improve culture, training, and support. She was aware that Post Office served vulnerable individuals in thousands of post offices nationwide, and it was of great importance to her that those people did not lose their confidence in the Post Office and continued to feel able to collect benefits and pensions and carry out other important transactions. So, in conclusion, Ms. Venables understands the strength of feeling about her, that of sub-postmasters, those directly affected by the wrongful convictions, and that of the public. She heard what Mr. Maloney said yesterday about apologies being difficult to hear, and she understands that position. She knows that any apology will offer little comfort to those affected. She cannot and does not try to hide from the fact that whilst CEO, she did not manage to uncover the truth about the extent of the bugs, errors and defects in Horizon as found by Mr. Justice Fraser. This is a matter of deep and constant regret to Ms. Venables, as is the fact that the convictions of the sub-postmasters were not overturned sooner. So Ms. Venables simply did not receive the information which she ought to have been given by her senior team, whom she trusted and to whom she delegated responsible roles. As she said herself in her evidence to you, I am very sorry that I was not able to find out what the inquiry has found out. I don't know today how much wasn't told to me. I do know information that I didn't get, and I don't know, in some cases, why it didn't reach me. Ms. Venables still does not know why key information was not passed on to her and explained. She believed her senior team and General Counsel to be working hard and doing their best to investigate the sub-postmaster's complaints in good faith. She had faith in them, and as far as she was concerned, had good working relationships with them. She is devastated by the fact that information was not shared with her. She has no desire to point the finger at others, nor to speculate as to why information was not shared. She trusts that you, sir, together with your panel, will establish the true extent of the information that was not shared, and perhaps why it was not shared. Throughout Ms. Venables' written and oral evidence, and borne out throughout the documents and evidence of others which have been adduced during the inquiry, we submit that there has been nothing to show that Ms. Venables acted in bad faith. Ms. Venables wanted to do right by the sub-postmasters. Sir, notwithstanding that the evidence phase of this inquiry has now concluded, Ms. Venables will continue to assist your investigation in any way she can.
Thank you, Ms. Leake. So we'll break off now until 11:25, when we'll hear from Mr. Whittam. Mr. Whittam.
Sir, Fujitsu thanks you for the opportunity to make this short oral closing statement to supplement Fujitsu's written closing submissions to the inquiry. As you know, Fujitsu has made careful, evidence-based written closing statements for phases 2, 3, 4, and collectively 5, 6, and 7. I do not repeat the content of those closing submissions. Fujitsu has reflected carefully upon the evidence given to the inquiry. In phase 1, the inquiry heard clear, detailed, and profoundly affecting evidence of the human impact of hostile investigations and wrongful civil and criminal proceedings commenced by Post Office against sub-postmasters and their employees. Phases 2 to 7 of the inquiry have exposed in detail the failings which brought about those appalling miscarriages of justice. The human impact phase of the inquiry reinforced the devastating impact of those events described by the sub-postmasters and the impact it had on their lives. As it has done previously, Fujitsu apologises for its role in the suffering of affected sub-postmasters, employees, and their families. Fujitsu's written closing submissions for each of the phases of this inquiry have accepted, clearly and candidly, where its own systems, processes, and people have gone wrong. Nothing I say in this oral submission is intended to detract from those acceptances. The evidence received by the inquiry has demonstrated that the issues which have arisen are not exclusively or even primarily IT issues. The miscarriages of justice with which this inquiry is concerned were not caused by technical failures alone, but are the product of serious human and organisational failures in conduct, ethics, governance and culture. Fujitsu's commitment to helping the inquiry understand what happened is reflected in the extent of its cooperation with the inquiry. Fujitsu responded to the inquiry's Rule 9 requests as fully and comprehensively as possible. At the start of the inquiry, warehouses were searched, databases were processed, and electronic documents from approximately 120 Fujitsu individuals were collected. More than 30 million records, electronic and hard copy, going back more than 25 years, have been collected. Throughout, Fujitsu has remained fully committed to supporting the important work of this inquiry. Having produced over 240,000 evidential documents, assisted more than 30 witnesses in the provision of written and oral evidence, and produced 5 detailed corporate statements. From the outset of this inquiry, Fujitsu has been clear about the technical matters that have now been the subject of substantial and careful examination. The first of these relates to the existence, identification, communication and resolution of bugs, errors and defects in the Horizon IT system. The second relates to existence and use of remote access by certain Fujitsu staff. I address these matters briefly in turn. In its opening statement to the inquiry, Fujitsu acknowledged that there have been a number of bugs, errors and defects within Horizon system, and that in some instances those bugs, errors and defects had the potential to, and indeed did, affect the integrity of sub-postmasters' branch accounts. Fujitsu has repeated this acknowledgement variously throughout the inquiry process. Fujitsu has also explained that no complex IT system will ever be completely free of bugs, errors and defects. That common sense proposition has been accepted repeatedly in evidence by numerous post office witnesses working across the inquiry's relevant period. Horizon is a multifunctional system encompassing points of sale services and over 100 additional services, including, amongst other things, financial services, government services and lottery purchases. It is a large, bespoke and highly complex system developed by Fujitsu in conjunction with Post Office for use in Post Office branches. It interfaces with numerous different Post Office and third-party systems. Initially, Horizon was rolled out between 1999 and 2001 and remains in use in Post Office branches across the United Kingdom today. Horizon was and remains but one part of the Post Office's IT infrastructure, supported not only by Fujitsu, but various other third-party suppliers. Both the inherent complexity of the system and the obvious potential for bugs, errors and defects necessitated that processes governing the identification, communication, escalation and resolution of bugs, errors and defects were put in place at the start and remain in place between Post Office and Fujitsu. Fujitsu has frankly accepted that whilst these formal and informal information sharing systems were generally effective in practice, they were not uniformly so. The evidence heard over the course of the inquiry nonetheless compels the conclusion that, in general, Fujitsu routinely and continually shared information concerning the existence of the impact of bugs, errors and defects with Post Office. It therefore follows the contemporaneous knowledge of bugs, errors and defects within Post Office went well beyond acknowledgement of the mere theoretical possibility of bugs, errors and defects. Post Office has been aware for at least 25 years of the potential for and existence of bugs, errors and defects in the Horizon IT system, as well as the potential for those which are unknown and unresolved to exist. Post Office was also aware in 1999 of the potential for bugs, errors and defects to impact upon the integrity of branch accounts. By way of illustration, in the annex to Fujitsu's final written closing submissions in this inquiry, Fujitsu has identified at least 70 individuals within Post Office and Royal Mail in relation to whom the inquiry has received unequivocal evidence of their knowledge of bugs, errors and defects. This includes members of the Post Office board, senior executives, in-house lawyers, as well as individuals working in Post Office's security and investigations teams. That knowledge spans the entirety of the period being examined by the inquiry. The sheer number of Post Office and Royal Mail personnel who were aware of the existence of bugs, errors and defects is potentially relevant to the inquiry's work in another way. A number of witnesses before the inquiry could either not recall with accuracy whether or in what circumstances they were made aware of the existence of bugs, errors or defects, or positively denied such knowledge in circumstances which might be thought to be surprising. In assessing that evidence, the inquiry will be entitled to conclude that, while of course knowledge held by one person cannot unfairly be attributed to another, and while Post Office's corporate knowledge cannot be aggregated for all purposes, the inquiry is entitled to infer from the breadth and depth of awareness of bugs, errors and defects within Post Office that it is likely that key institutional decision makers did, in fact, have such knowledge. The question of why this expansive institutional knowledge was not appropriately considered by Post Office or its legal representatives in the context of proceedings against sub-postmasters is a significant one, and a matter that will no doubt be the subject of careful deliberation by this inquiry. Further, in its opening statement to the inquiry, Fujitsu accepted that Fujitsu staff had and continues to have the ability to remotely access Horizon. That access was and is possible in multiple ways, via various ingress access types, from the time of the initial rollout until now, including in both Legacy Horizon and HNGX. Fujitsu has reiterated this position throughout the inquiry. Remote access was and remains a necessary part of the suite of support tools available to manage the live operation of the Horizon IT system, including the attempts to rectify bugs, errors and defects. Indeed, support staff from Fujitsu state in evidence that they could have not done their jobs or operated Horizon without it. In its opening statement to this inquiry, Fujitsu submitted, I'm sure you will recall, sir, that Post Office had been aware from an early stage of Fujitsu's ability to remotely access the Horizon system. That submission has been borne out by the evidence given to the inquiry and was belatedly accepted by Post Office in its final closing submissions. But whilst abuse of remote access privileges by a malign actor cannot positively be excluded on the evidence, there is no evidence for it and no reason to suppose it occurred. Most importantly, there's no evidence to support the suggestion that remote access privileges were used for any purpose other than to provide necessary technical support to Post Office branches. In other words, there's no evidence to support any suggestion of the malign use of remote access capabilities. It's regrettable that in its written closing submissions, Post Office sought to obfuscate its proper share of responsibility for the events which are the subject of this inquiry by seeking wrongly to deflect blame to Fujitsu and other third parties. Post Office has sought to characterise itself as the subordinate partner in the relationship with Fujitsu and as operationally and technically dependent on Fujitsu. Perhaps tellingly, sir, you might observe that these submissions, it's paragraph 101 in the Post Office written closing submissions, are unsupported by any reference to the evidence before this inquiry. That's unsurprising, because the submissions bear no resemblance to that evidence. So you'll be aware that Post Office previously has sought to shirk liability by deflecting responsibility for its share of organisational failings in its submissions to the Court of Appeal in March 2021 in the case of Hamilton and the Post Office. The Court of Appeal rejected that attempt, holding that Pol knew that there were serious issues about the reliability of Horizon. If Pol needed further information, it could have obtained it from Fujitsu. That was a finding that was omitted by the Post Office when quoting that same section of the judgment in paragraph 10 of its written closing submissions. The evidential basis for that conclusion is even stronger on the evidence before this inquiry, and we would invite you to adopt the same course as the Court of Appeal. To the extent that it is ever appropriate to describe one party to an extensive and sophisticated commercial contractual arrangement like the Horizon contract as subordinate, is clear beyond argument that the Post Office is not such a party. Post Office has been and remain very much in the driving seat of that contractual relationship. As we saw in phases 2 and 3, it was Post Office who specified the technical requirements by which the Horizon IT system was developed and by which it has been changed over time. As we saw in phase 4, it was Post Office who determined the nature and extent of the prosecution support which Fujitsu was required to provide, including, by way of example, stipulating the form by which the ARQ requests were made. Even in phase 7, we see the arrangements for the end of service life of Horizon IT system continue to be sensitive to Post Office's commercial needs, despite Fujitsu's serious reservations. More generally, the evidence for Post Office dependency on Fujitsu is conspicuously thin. Post Office has at all material times had its own IT function. It's employed a number of IT specialists, including highly experienced individuals such as Leslie Sewell, who held positions of management and oversight concerning all of Post Office's IT functions, including the Horizon IT system. As would be expected, the business-as-usual operation of the Horizon IT system entails the sharing of vast quantities of information about the system, including, again entirely unsurprisingly, about technical issues and bugs, errors and defects. In the annex to our closing submissions, Fujitsu has summarised some of those key means of information sharing. Post Office has also had at significant times throughout the life of Horizon its own testing teams, tasking with ensuring the quality of certain releases of Horizon. Post Office relies upon what it describes as repeated assurances from Fujitsu that Horizon was reliable. It does not cite even a single example of such an assurance being given. To the extent that certain Post Office witnesses similarly suggested that they'd been provided with assurances as to the integrity of the Horizon IT system by Fujitsu, there was a complete lack of evidence to support those claims. Indeed, as Fujitsu pointed out in its Phase 3 closing submissions, those claims were either entirely vague and, confusingly, often made by individuals with no direct engagement with Fujitsu at all. A better view of the evidence, sir, as Fujitsu submitted at the end of Phase 3, is that a message from the top within Post Office consistently emphasised, without evidence, the robustness of the system. Having said that, sir, to be absolutely clear, despite the observations that I've just made, and also will continue to make about Post Office, I repeat, Fujitsu stands by all the matters it has accepted in its written closing statements. Post Office investigations and prosecutions did not begin with the introduction of the Horizon IT system. Post Office had an established, active investigation and prosecution function in place prior to the national rollout of the Horizon IT system in 2000. The available evidence demonstrates a significant increase in investigative and prosecutorial activity during the period of 1992 to 1998. This initial increase in investigative and prosecutorial activity occurred following the introduction of an in-house accounting system called Capture into Post Office branches in 1992 and predates the rollout of the Horizon IT system. The conduct of criminal prosecutions on behalf of Post Office fell considerably short of the important duties which apply to a private prosecutor. Hundreds of sub-postmasters were wrongfully prosecuted. Indeed, the evidence now available to the inquiry suggests that the failings in the conduct of Post Office prosecutors were considerably more fundamental than even those acknowledged in the Court of Appeal in the Hamilton and Post Office case. In Phase 4 of the written closing submissions, Fujitsu made detailed submissions as to the wide range of serious deficiencies which undermine the integrity of Post Office prosecutions. I do not repeat those submissions today. Fujitsu nevertheless acknowledges that the codified agreement between Fujitsu and Post Office contained novel propositions, contractually obliging Fujitsu to provide support to Post Office in respect of prosecutions. That work was atypical for an IT service provider such as Fujitsu and was outside the normal work of Fujitsu technical staff. It is a matter of profound regret to Fujitsu that it ever provided services to support Post Office proceedings against sub-postmasters. Fujitsu was never cited on the full scale of Post Office's prosecutorial conduct and misconduct, and so that's plain from the fact that it did not provide evidence in all the cases. Nonetheless, Fujitsu accepts that it was inappropriately deferential to Post Office as its client, and its senior management were insufficiently interventionist in their management and oversight of the Post Office account. This led to a failure to properly challenge or scrutinise the appropriateness of requests made by Post Office and resulted in Fujitsu providing a service, prosecution support, which fell short of its own corporate values. In light of this, Fujitsu recognises that it failed properly to support those of its employees who engaged directly with Post Office and its lawyers in respect of prosecution support. This is particularly so for those who engage in the provision of documentary and witness evidence in relation to Post Office prosecutions and civil actions, with technical employees often left to engage directly with Post Office internal and external lawyers, rather than having appropriate mechanisms by which to monitor and support those employees. In his written closing submissions, Gareth Jenkins notes particular failings of Fujitsu in its management and oversight of the prosecution support which he came to be required to provide. So I can make it clear that Fujitsu accepts those failings. In the course of Phase 7, the inquiry explored issues regarding ongoing and future criminal investigations and prosecutions involving Post Office. Post Office's renewed interest in criminal investigation and prosecutions appears to be driven by a perceived need within the Post Office for a deterrent and to recover apparent shortfalls. Despite the startling evidence heard during Phase 4 of the inquiry in relation to the conduct of Post Office investigators and lawyers in the context of proceedings against sub-postmasters, as recently as July 2022, Post Office boasted in internal documents that its investigations unit, the first recognised investigations unit in the world, it claims, has an unblemished reputation. A significant focus of that evidence, and regrettably a source of some confusion in the Phase 7 evidence, was the nature of assistance, if any, which Fujitsu had provided or was willing to provide in support of such investigations. Moreover, Post Office's engagement with ongoing law enforcement investigations raises real questions as to the extent to which lessons have been learned regarding the matters which have been the subject of this inquiry. Fujitsu has set out that position in detail in its final written closings to ensure that that concern is fully aired. But in summary, it's as follows. Between February and July of 2024, Fujitsu was contacted by 4 police forces in relation to 4 cases. This apparent flurry of criminal investigations, each of which appeared to have been referred to the relevant police forces by Post Office, caused Paul Patterson and his colleagues at Fujitsu such concern that Mr. Patterson felt it necessary to escalate the matter to Nick Reed as the CEO of Post Office. Mr. Patterson was particularly aggrieved by some of the language used by Post Office staff in context of these criminal investigations, and the apparent inference by those members of staff in what appeared to be matters relevant to the police forces. Fujitsu does not know why it has not been contacted by the other police forces in connection with other investigations. It's been suggested by some core participants that this correspondence and Fujitsu's correspondence with some police forces may reflect tactical positioning for the purposes of the inquiry. So I can be completely clear on that front. Inevitably, Fujitsu's attitude to the use of data derived from the Horizon IT system in criminal investigations and prosecutions has been informed by the shocking evidence heard by this inquiry. Fujitsu is astute to ensure that it does not repeat the mistakes of the past, and to ensure that it does not lend its assistance to Post Office in repeating those mistakes. Moreover, far from that tactical positioning, Fujitsu's position regarding ongoing and future criminal prosecutions has remained consistent since its declared position on the 16th of June 2020 in its letter to the Bayes Select Committee that it will provide information to the police and other appropriate judicial authorities, but not to Post Office-led prosecutions. To reiterate, Fujitsu has offered and will continue to offer full cooperation to any police force conducting an investigation into potential criminal wrongdoing in connection with Post Office branches. Fujitsu will cooperate with police forces in the preparation of factual witness statements to address matters relevant to those criminal investigations. Fujitsu is, however, determined not to repeat mistakes of the past, which have been so starkly revealed by this inquiry. In this context, Fujitsu is acutely aware that it is not in a position to offer independent expert opinion from any employee regarding the operation of the Horizon IT system. Fujitsu is also aware of the need to make full and appropriate disclosure regarding its knowledge of bugs, errors and defects in the Horizon IT system, including the potential for unknown, undiscovered and unresolved bugs, errors and defects affecting the live system, particularly as it ages without further investment and the existence of remote access. In addition, Fujitsu is also mindful that a consistent theme of the evidence before the inquiry was the error in producing evidence for criminal proceedings from the Horizon IT system data, of focusing overly narrowly on whether there is a specific evidence of a bug or error or defect affecting a particular branch at a particular time, as compared to the potential for bugs, errors and defects, including the unknown ones, within the network more broadly, and is eager that police forces do not repeat the same error. In other words, by asking Fujitsu to provide evidence limited to a particular branch. Relatedly, Fujitsu has become concerned by some of the correspondence it's reviewed between the Post Office and the relevant police forces. In particular, the letter sent by post office to the Lancashire Constabulary on the 25th of April of this year, and then provided by the Lancashire Constabulary to Fujitsu some 3 months later, on the 24th of July 2024, is significant in a number of material respects. Fujitsu sets out the severe deficiencies of the content of that letter in its written closing submissions. However, in the context of the apparent resurrection of Post Office's criminal enforcement activity and the quick dismissal of Fujitsu's concern by both Mr. Reid and Owen Woodley, the content of that letter seemed to Fujitsu to be so egregious that Mr. Patterson decided to write to Post Office 2 days later to cease any further correspondence on the matter. There is no merit whatsoever in the suggestion, principally made by John Bartlett, that Fujitsu has been obstructive or uncooperative with police investigations. Fujitsu is surprised by that suggestion, which is plainly at odds with the evidence. Further, given the significant miscarriages of justice with which this inquiry is concerned, a cautious approach in these cases is both reasonable and appropriate. In its opening statement to the inquiry on the 4th of October of 2022, Post Office submitted that it embarked on an ambitious and accelerated large-scale effort to retire Horizon by 2025 and replace it with a new system. Over the course of Phase 7, the inquiry has received evidence concerning MBIT and the progress that has been made towards replacing the Horizon IT system. Increasingly, it's become clear that the MBIT programme has experienced prolonged delays and technical challenges. It's also become clear that Post Office is no closer to replacing the Horizon IT system than it was at the beginning of this inquiry when it made its opening statement. In the interim, and something of concern, insufficient investment has been made in the Horizon IT system. The Horizon IT system is on an end-of-service life IT infrastructure, and due to this status and its age, there's an increasing risk of the existing Horizon IT system infrastructure failing. That could inversely impact the delivery of services to the public. Since 2020, Fujitsu has consistently communicated its concerns to Post Office in relation to supporting end-of-life service infrastructure, and that it wishes to exit the Horizon contract. Sir, as I've said, the core of this inquiry are the sub-postmasters and their families who were so profoundly and tragically affected by the appalling miscarriages of justice. Fujitsu reiterates its sincere apology to the sub-postmasters, employees and their families. The inquiry has conducted a thorough and searching investigation. The work of the inquiry has revealed the technical, human and organisational failings which contributed to the suffering of sub-postmasters and their family. Fujitsu accepts its share of those failings and has set out in writing the detailed matters which it does accept. That said, the relative brevity of this oral closing and the shorter than some written closing should not be taken as an acquiescence to all the criticisms levelled at Fujitsu, particularly some of those I've touched on by the Post Office. As already I have submitted, prior to the commencement of this inquiry, the appalling miscarriages of justice that have now been laid bare by the evidence received by this inquiry were framed as resulting primarily or exclusively from IT issues. That is, evidence has demonstrated that these miscarriages of justice were not caused by technological failures exclusively or even primarily, but are instead the product of serious human and organisational failures in conduct, ethics, governance and culture. Fujitsu hopes that having supported the inquiry through its work, it has gone some way to demonstrating its commitment to learning lessons from the inquiry process, and most importantly, to ensuring that the mistakes of the past are never repeated. Thank you, sir.
Thank you, Mr. Whittam. So it's just about 12 o'clock. Ms. Dobbin, would you like to make your submissions in one go? Answer, I suspect, yes. So would you like to have an early lunch or make them now?
Sir, I would like to make them in one go, if that's okay.
And would you prefer to make them now, or shall we take an early lunch?
Well, so perhaps if we took an early lunch, if that was all right.
Yep.
Thank you.
So we'll begin again at, 1 o'clock.